Listen to me, your boss is not going to jail because you're stressed, and believing that could ruin your life. Millions of people are watching psychosocial videos right now, and the intention behind them is good, but some of the claims are dangerously wrong. And when you act on the wrong version of the law, you don't just risk embarrassment, you risk losing your job, income, housing, and serious mental health problems. And my genuine concern from seeing some of these videos is that if you go to your employer armed with the knowledge that is wrong, there is a real risk that you could be fired. And the problem is, once you're dismissed, even if it was unfair, fighting it through the tribunals and courts can become very expensive and a lengthy process. And at that stage, your life is already set on fire. So stay with me for the next 60 seconds and you'll walk away knowing what the law actually says, what is and is not a psychosocial hazard, and actionable steps if work is genuinely harming you. I'm a lawyer, and I teach law at university. I spend my days explaining what legislation actually means. So let's clear this up properly. So let's start off with what a psychosocial hazard is. A psychosocial hazard has to come from how work is organized, controlled, or designed. So for something to be a psychosocial hazard, it would look something like sustained bullying or harassment, credible threats of violence, forcing someone to repeatedly view graphic content, ignoring months of serious complaints, and knowingly assigning workloads no human being could possibly perform. Let's say that a workplace forces employees to watch trauma footage daily. No measures in place to assist them, people beg for help, and yet the workplace does nothing. That is a psychosocial hazard. But being overwhelmed from a busy period, having panic attacks from personal stress, or being upset, tired, or unhappy with performance feedback is not. Now, your feelings are very real, but the law requires a very specific connection to work design. Now, bear in mind we're talking about risk here. So when you're talking about physical risk, for example, let's say 4 people standing on top of a building with no protection from falling off of it, the risk is the same for each of them. Each of them would react in a very similar way if they fell 10 meters. But psychological or psychosocial risk is very different. You could be exposed to the same stimuli across, let's say, a group of 5 people, and each one of those people could react very differently, ranging from unaffected to shaken to traumatized for life. Same stimuli, 3 very different responses. And this is exactly why the law uses terms like foreseeable risk and reasonably practicable. It's also the reason that employers struggle so badly to comply, because there is no one-size-fits-all policy. Every policy carries unique risks because of the fact that people's brains react differently. In the spirit of continuing to clear up these myths, we will deal with the liability myth first. Without going into the sections of the Act, the PCBU, or the business, holds the primary duty, and only senior officers have personal due diligence duties. Now, it's true, workers and supervisors have a duty to take reasonable care, but this is not personal criminal liability for somebody else's stress. So your boss may not be liable personally at all, depending on the structure. But what I can tell you is that it would be extremely unlikely for your team leader to be looking at jail time because of a stress-induced injury. One of the other things that came up in these videos is this concept of your boss going to jail. Now, the threshold for jail under the regulations is quite high. Jail is a possibility for Category 1 offences. They're the most serious. And an offence of that kind requires reckless conduct exposing someone to a risk of death, serious injury, or serious illness. It isn't burnout and it isn't panic attacks. I haven't been able to find a single offence for a Category 1 psychosocial hazard that was successfully prosecuted. The threshold is that high. Now, with that cleared up, there are steps that you can take if you believe work is genuinely putting you in harm's way. So here are 5 actionable steps that you can take. Document everything, report your concerns, speak to a GP or psychologist, contact the regulator for serious cases, and please get proper legal advice before making any serious decisions. To be abundantly clear, this isn't legal advice, this is information. For this to be legal advice, I'd need to know your personal circumstances and we'd need to have some sort of formal agreement in place. If you want a full breakdown on this, the actual law, not the algorithm's preferred version, I will be posting a full detailed breakdown on my YouTube channel, James Glisson Official. And if you know somebody who's been confused by the viral videos, please share this. This is very important to get right, or at least to not get wrong. We all deserve a safe workplace, but the purpose of this video is to make sure that you don't weaponize a law that doesn't exist in the way that you thought it did. The consequences can just be catastrophic.